Hi there, and welcome back to another episode of Divorce Well in Florida. What to know before your spouse does. Brought to you by Fairway Law Group. We're a Florida divorce law firm. I'm here with my partner, Brian Dunmire. My name is Matthew Waring, and we just discuss different topics in Florida divorces, things that really clients should know before they get a divorce, while they're getting a divorce, information that's going to help clients out.
Yeah, and as Matt said, my name is Brian Dunmire. I am one of the attorneys here at Fairway Law Group. I am in the Orlando office. Matt is down in sunny Deerfield Beach, and we are both divorce attorneys. We handle divorces throughout the state of Florida, and we're here today to talk about very interesting topic. It's one thing that comes up in everything, mediation. But before we get to that, Matt, you work on anything this weekend? Do you do any...
Yeah, man, I got down and dirty with some home renovations. Did a lot of work Saturday and Sunday. Built some shelves in a closet. Did some drywall work. Just a way to really blow off some steam after a hard week of handling family law cases.
Nice. I got this new tumbler this weekend at Home Depot. If anybody's looking for a new tumbler recommendation for coffee or water or anything like that, I got this. It's a Milwaukee brand tumbler. I'm pretty excited about it.
Yeah, I love it. I love it. Now, the question is, I know that Project Farm on YouTube did come out with a review video of tumblers, and I'm just wondering if he did in fact test the Milwaukee tumbler against the Yetis and the other tumblers and what the conclusions were. That's just not an episode I've really been able to sink my teeth into yet.
I have watched that from start to finish a couple of times now. I don't remember him doing the Milwaukee tumbler, but he definitely did Yeti and Stanley and the other ones like that. And yeah, they all spill.
Yeah.
So don't turn them upside down.
Got it. All right, will do.
Yeah.
All right, so talking a little bit about mediations here. If you have a family law case in Florida, you're going to go to mediation. Judges around the state require mediation in pretty much all divorce cases. If you haven't already been to a mediator, you're going to go to one. But just to start things off, a little bit of a controversial opinion, and this is my opinion, not all attorneys share this opinion. I think mediating before filing a divorce case is a complete and utter waste of time and money. What do you think?
I completely agree. There's one little caveat to that, and the attorney side of me is coming out. Everything that you just said is correct, but you said before divorce case, if you're filing a divorce case, it means that you haven't previously been divorced. If you've already been divorced and you're doing a child support modification or some sort of modification type case, inside of your previous final judgment, there might be a requirement that you mediate before you actually file a new lawsuit, so you might be required to. But what you said, 100% accurate, 100% correct. I don't see any reason why you'd want to mediate before you actually file a lawsuit. And I'll let you explain it a little bit more than me, but what I will just say is that one of the reasons why you don't want to do that is just... If you show up to a mediation before a case is filed, number one, unless you're an attorney, you're probably not going to know what the hell you're actually resolving or trying to resolve, because there's numerous issues that are resolved in a divorce. Equitable distribution, time sharing, inside of equitable distribution, who gets the house, who doesn't get the house, how do you split the proceeds, things like that. So, you want all that information in front of you before you go to mediation. But Matt, you can explain why
and
you
even
actually
if,
want
and
to
I'm
wait.
not going to change my opinion, even if you have already been divorced and you have a parenting plan or a marital settlement agreement that says that before you can file for any sort of modification, you have to go back and try mediation. I still think it's a waste of time and money. The reason why, if you really want to know the inside reason why people put those provisions in contracts, in marital settlement agreements and parenting plans, is to deter people from even filing a modification. It's called a barrier to entry. It just creates a roadblock. It slows you down before you can go out and file a modification to your previous, marital or divorce judgment. If you've got to go and organize a mediation with your ex-spouse, that's going to take months. And then you each got to pay money. Nobody's going to do it. But since it's a a necessary condition to filing a modification case, it's going to keep more people out of court. So I'm sure that the courts and judges love it. I still think it's a waste of time. Yeah, go ahead.
Yeah. No, I tend to agree with you that it is a waste of time. Could be a waste of time. And, as attorneys, we will say that you should always follow court orders and previous judgments and do every single thing that they say. And if that's a condition precedent before filing a modification action, you should do it. However, if you don't do it, it's probably not going to be the end of the world. You can file some sort of motion to stay. But even if for some reason you're one of these people, because you get the phone calls from time to time, I want to go to mediation, I just want to hammer everything out. And you want to do it before a lawsuit is filed, before you just want to get divorced, you just want to do it. Your time and your money is probably going to be better spent retaining an attorney and having them draft everything in the form of a letter and then trying to negotiate a settlement. And we don't do this very often because it just, quite frankly, doesn't make any sense.
We'll talk about that on some other different podcast, why we also think that that's also a waste of time and money. But today we're talking about one, mediation is a waste of time and money.
Yeah, but your time is probably going to be better spent. Time and money is going to be better spent retaining an attorney and having them trying to facilitate some sort of settlement negotiations before the filing of the petition. And then if everybody comes to an agreement. But here, as we talk this out, I'm even thinking about this. It doesn't make any sense because you're still going to need to file the petition and comply with everything in the court action.
Exactly. So you're
going to be spending the money anyways.
That's why it's a waste of time and money, because you get these people and they want to resolve their case without filing a lawsuit. Well, unfortunately, you're going to have to file the lawsuit anyways because the judge can't enter a divorce until it's before the judge. And the only way it gets before the judge is you got to file the lawsuit. You have to file the divorce case or else you can't get divorced. And if you mediate before filing the case, good to go. But you still have to file it. You still have to pay the filing fees. And you're probably going to end up still needing a lawyer to get it all the way through and in front of a judge. And then on top of that, what if you've got a minor child? You're going to end up mediating again because the judge is never going to enter an order. Even if you agree on every single thing, it's reversible error for the judge to enter a final judgment of divorce when there's minor children in the marriage without child support guidelines and without financial affidavits being filed in the case. And then guess what? When you start talking, you might agree to everything. But as soon as you start talking about child support and financial affidavits, a lot of those agreements go out the window. And then guess what? You're going to have to mediate the case again. So the only person that really wins is the mediator who gets paid twice.
Which is actually what you just brought up is one of the reasons why it's so important to get an attorney, even in an uncontested. If you're listening to this on Spotify or Apple Podcasts, I'm putting uncontested in air quotes, because even in an uncontested case, it's so important to get attorneys because you never know when things are going to go south. A lot of times when people see the child support award or a financial affidavit or something, an uncontested case becomes contested. But that's something to talk about on a different day. As it relates to the mediation, here's the other thing too. If you do an early mediation, meaning before the petition is filed, and it impasses, so for those of you who aren't lawyers, impasse is the word that we attorneys use when a mediation doesn't resolve, doesn't reach a settlement agreement. Same thing as just a failed mediation or it didn't work, whatever way you want to say it. But you'll hear attorneys use the word impasse all the time. So if you go to a mediation before you file a petition and it impasses and then you end up in a divorce case, there's also a pretty high likelihood that a judge, as a matter of course, is just going to refer you back to mediation. Just because if I'm a judge and I'm at a case management conference, because that happens in family law cases, a lot of judges just have case management conferences, and that's kind of what it sounds like, where the judges are just actively managing the cases. And I have somebody come up and say, yeah, Judge, we mediated this case. Oh, okay, when did you do it? Oh, February of 2024. Well, this case wasn't filed until April of 2024. Yeah, we mediated before the case. If I'm a judge, I'd probably send you back to mediation because now you've got all the financial disclosure. There's litigation. There's it's a lot more real, because that's one of the things, and this will be a nice segue to actually talk about the benefits of mediation. One of the reasons why mediation actually works is because there are consequences to not settling the case, and it's everything from perhaps more invasive discovery from your spouse, or maybe you're waiting on submitting a subpoena to a bank or something like that because you thought your husband was going to some bar that he otherwise shouldn't have, or whatever it might be, or quite frankly, just attorney's fees. If there's not a lot of assets on the line, and you're right on the brink of a settlement, but you really wanted the China set, but your husband's not agreeing to it, you got to make a determination. Is $1,000 plate worth litigating your divorce case for 6 more months? Because it's probably going to take more time, more money for your lawyer to write a letter discussing something than it would be to just resolve it and go buy a new plate. So when you're inside of the context of a case and you go to a mediation, there's a lot on the line. And the examples that I just gave are very small examples. There could be much bigger things on the line.
Or not.
I mean, there could be nothing on the line. And, some of the most frustrating cases I've had is when the case absolutely should have just settled at mediation, and it just didn't. It just didn't, because the parties couldn't agree to something.
Like a plate. Yeah.
Like a plate.
It happens. So the issue when you mediate before filing a petition is that that you might have to mediate again after you do file the petition. So this is really just a dress rehearsal. So you don't have any skin in the game. You haven't paid lawyers yet. You haven't paid the circuit court filing fee yet. There's no deadlines yet. You haven't had to do any financial disclosure. You just don't have skin in the game. So both parties can come in there and pound their chest and demand that they want certain things. Or in the other way, they might even go in there and have a very collegial relationship and be able to work through a lot of things and reach a lot of agreements. But it doesn't really matter, because you're not going to get to a sound agreement, not necessarily a good agreement like we've talked about on prior episodes, but a sound agreement, an agreement that is in light of full financial disclosure. You've had the opportunity to conduct discovery. You're satisfied with the discovery responses that you've received. You're satisfied with all the disclosures made by the other spouse. And then you reach an agreement inside of a case that is going to be much stronger and a much better use of your money and your time than a dress rehearsal mediation that you have before filing a divorce petition.
Yeah, and part of the reason why somebody might be tempted to even make the suggestion of going to mediation before a divorce is filed might stem from the fact that the everyday public, if you're not a lawyer, might not actually know what a mediator's job is. A mediator doesn't make determinations. A mediator doesn't decide who's right and wrong. A mediator doesn't argue for you, doesn't go into your spouse's room and say, I rule this way. A mediator conveys messages. Okay. A mediator conveys messages. So mediations, when you pay somebody not a small amount of money, and back in the day before Zoom, you'd all be in the same room together. You say your opening statements, and then you split up and you go into separate rooms. That's called caucusing. And you split up into separate rooms. So you'll be in room 1, your spouse will be in room 2, and the mediator literally would go in between the rooms, walk from room 1 to room 2, from room 2 to room 1, and convey settlement offers. Now on Zoom, we go into separate breakout rooms, but it's the same concept. Mediator goes from this room to that room to this room to that room to that room to this room. And an early mediation has no teeth because the mediator can't do anything except convey messages. So you don't go to mediation, you don't submit your case to mediation and the mediator tells you what his or her findings are. You go to a mediation and you say, this is what I really want, but I'm willing to wiggle around on this. And in the terms of the way that we prepare our clients for mediation is you always ask for a little bit more than what you want, and then because we can always come down, but once you kind of concede something, it's a little bit difficult for it to come back into the picture unless you're willing to give something up. So a successful mediation is going to be when both people are pissed off at the end, okay? Because that means that you gave a little bit more than you initially thought, and the other person gave a little bit more than they initially thought. Matt and I have both been to hundreds of mediations at this point in our careers, and virtually every mediation that's resulted in a settlement agreement, typically the client is maybe like a little annoyed, a little upset because they gave up. They went into the mediation. I'm never going to agree that, I'm going to give the joint checking account that has $5,000 to my spouse. And then they end up giving the joint checking account to the spouse. And it's not because they weren't represented well or we didn't fight for them or anything like that. It's because that's what the mediation process is for, is to say you can bring a resolution to this case with certainty today, or you can not give up that $5,000 checking account and continue to litigate this for in between 6 months and 2 years and spend $5, $10, $15, $20, $25,000 litigating that sole issue. And when you have a mediation and you really understand what's at stake and you're willing to kind of put emotions aside and make very logical decisions, you ultimately can get to a settlement. So Matt, actually with that, I'll put the ball back into your court. Well, can you talk a little bit between making logical decisions and emotional decisions at mediation, and how emotional decisions might harness or prevent a settlement from occurring?
Yeah, I mean,
it's a big question. It's a big ask.
At a divorce mediation, I don't care who it is. Everybody comes into a divorce mediation with a sacred cow. Now, what do I mean by that? A sacred cow is there's something that they do not want to sacrifice. There is at least one thing that they do not want to give up. And it could be a range of things. It could be a specific financial account. It could be a specific item. It could be a pet. It could be a specific amount of time that they spend with their child or children. Whatever it is, most clients have that one thing, that sacred cow they're not willing to sacrifice, and they get very, very emotional about that item. And a common divorce mediation tactic is, when you're aware of the other side's sacred cow, is to go after that item. Because by going after that sacred cow, it automatically is going to make them get into an emotional frame of mind, and they're going to start making bad decisions, and they're going to start to give up other things in order to make sure that they can keep that sacred cow. Because here's a big thing that you got to understand psychologically, and it factors into divorce mediations, is however much joy you get from obtaining something, losing it hurts twice as much relative to the amount of joy that you received when you got it. So if you're in possession of that sacred cow and you have that thing, and the other party is threatening to take it away from you, that pain that you feel twice as much. You might enjoy this thing, or you might appreciate this thing. Losing it is twice as bad as getting it in the first place. You'll do everything to avoid losing it, and you'll start giving up other things. The best thing to possibly do heading into a divorce mediation, to be in the right frame of mind, to think logically and not emotionally, is to be honest with yourself, identify what your sacred cow is, and don't bring it up, and don't make it important, and don't make it relevant. Most likely, you'll walk away with it. If you talk about your sacred cow at the very end of mediation, like you've already divided all the property, you've already come up with your parenting plan, and you almost got a deal, and you wait way off to the end of the mediation, and you're like, oh, and by the way, I want the 1996 Jeep Wrangler. Whatever it is that thing is that you desperately want, you leave it at the end, and you have a much higher likelihood of walking away with it than you would if you start that mediation. You say, hey, before we talk about anything else, I want the 96 Jeep Wrangler. The other party's going to pick up on that, and they're going to use that against you throughout the rest of the mediation. So that's a good insider's tip. Don't let your spouse know what your sacred cows are. Don't let everybody else know. Keep it to yourself. Tell your lawyer, hey, this is what I really want. This is what's really important to me. Don't bring it up. Don't discuss it. Don't get into a fight with your spouse before you're about to. And this is another reason why we don't like these pre-suit mediations or these mediations where people try to resolve everything prior to filing a case. Again, like we said, the case has to get filed anyways. You're going to have to mediate anyways. Save it for the case when you have representation. Because when you do it before you have a lawyer, you go into this mediation, you're unrepresented, you don't know any of this stuff, and you start arguing, and then you start tipping your hand. You start showing the other side what your sacred cows are, and now they know where the leverage points are. They know where the pain points are. And then when you get into litigation, then you're actually fighting for that thing you want versus just being able to ensure you get it by just letting it ride. So that's where people kind of make mistakes and get into an emotional frame of mind. One other thing that I wanted to talk about, divorce is mediation is a very excellent tool. It's like the best tool that we have in family law and divorce cases. We get so many of our cases settled at mediation, and even if they don't settle at mediation, we make so much headway. We might settle 90% of the issues when we leave that day, and we might only have to litigate 10% of the issues. So that's a win in our book. Mediation is not helpful, and it's also a waste of time and money when you're not prepared for mediation. When you're not satisfied with your spouse's financial disclosure, when you think that there might be assets that they're hiding that you don't have any information about, mediation is going to be pointless. Because you're never going to be able to reach any agreement at the mediation because in the back of your head, your spouse might be hiding something. I'm not talking about hiding, infidelity or, I'm not talking about that. I'm talking about specifically money and things of value. Maybe the spouse has a business and they've got a lot of their money tied up in the business, and that money is marital income, but since it's shielded in the business, you don't know about it at mediation. Why mediate the case? You can't settle. So mediation is helpful. It's a great tool. You got to be prepared. And guess what? You're not going to be prepared before filing a lawsuit. You're going to be prepared after financial discovery and after a lawyer conducts enough discovery so that you know what your spouse has.
Yeah. And just to touch on a couple of things that you just said, if you think that your spouse is hiding money, as attorneys, we've got things that we can do to figure that out. But just a tip of advice for everybody, save a little bit of money for yourselves. Don't just call up your attorney and say, I think my spouse is hiding money. Okay. If I'm your attorney, I go, can you give me some information? I know that they have a secret bank account. Okay. Anything else?
It's a double secret bank account.
A double secret. Oh, I think it's in a bank in Wilmington, North Carolina.
Delaware.
Okay. All right, Delaware. Wilmington, Delaware. Or North Carolina. But we'll go Delaware. That's even funnier for those of you who own businesses. You'll understand that joke. Okay, so you think your spouse is hiding secret money in a bank account in Delaware. Okay, cool. What do you want me to do about it? Well, I want you to find it. Okay, all right. It doesn't help us, okay? Now, you should, of course, tell your attorney if you think that your spouse is hiding money. I'm not suggesting that you shouldn't tell them that. But if you could at least kind of guide your attorney a little bit, down the path, then we might be able to engage in some discovery, and that discovery can range from everything. If you happen to know the bank and the bank account, or maybe a social security number or something, we might be able to issue a subpoena and get the bank records. We could definitely do that. Somewhat easier said than done because they're financial records and they're always a pain in the ass to get, and they're going to be protected and everything. But if you think there's a significant amount of money, it's definitely something that is worth doing. But the reason why I bring that up is if you show up to a mediation, you're just like, I know my spouse is hiding money. And I'm your attorney and I say, okay, well, where is it? I don't know. I just know they're hiding money. All right. Is it under the mattress? No, because I checked. Okay, well, what do you want me to do with that? And then what you're doing is you're putting up an artificial roadblock to potentially resolving the case on more or less a conspiracy theory. Okay. Now there are always going to be cases where people are hiding money, and if it's a well-founded, you know, inkling that you have, if your spidey sense is going off that your spouse is hiding money, you know, bring that up to your attorney, try and flesh it out, try and figure out what it is. But a couple of things here. The day before mediation is not the day to bring that up, because we can issue discovery. We can ask them. It's called interrogatories. We can do a request for production. We can go as far as taking their deposition, which is one thing that I love to do as an attorney. Not a lot of family law attorneys like doing it, but we can take their deposition, get them under oath. You swear to tell the whole truth, nothing but the truth. Yes. Okay. Thank you. Tell me about a bank account in Delaware you have, you know, and then they get all shifty in their seat, and you know you've got them and everything like that. But if you bring that up for the first time at mediation, it's going to be no bueno, because there's not going to be anything that we can do, and then you just wasted a day when you otherwise might be able to do it to get the case resolved. If you go to mediation, here's a wonderful thing about mediation, and Matt touched on this, is if you go and you're at least somewhat prepared, okay, at least say 80% prepared, and you go there in good faith, it's a no-lose situation. I mean, you cannot, it's the best money that you're going to spend, and here's why. Number one, you're going to walk away with a settlement agreement, okay, and your case is going to be done. I had a mediation a few months ago, and we resolved it at 5 or 6 o'clock in the afternoon, and I guess the judge was working some early morning hours, and we got a final judgment at like 5:30 in the morning. Now, that was a little bit more the exception than the rule, but to say, you know, we resolved this case on a, say, Thursday night at 5 p.m., and there's a final judgment at 5:30 a.m. on a Friday, I mean, that's pretty cool when you think about it. So, you know, that's a very obvious one. The less obvious one is going to be partial mediation settlement agreements, okay? A stipulation to sell a stipulation to sell a marital property. Maybe you've got a $3,500 a month mortgage and you can't really afford it anymore, but your spouse is being a pain in the ass and you and him can't really agree on what you want to do with the property. And so you spend $1,000 or $1,500 on a day at mediation, and the mediator goes back and forth and says, well, what happens if we list the property for this amount of money with this realtor? And then you walk away with the stipulation to sell the home, and the rest of the case, remember the word, impasses, but you settled that one portion of the case. Well, your home is sold. You're good. You got a partial mediation settlement agreement. So there was some progress made. But here's the beautiful thing. Even if there's no full agreement, even if there's no partial settlement agreement, if there's no agreement at all, both parties just slam their fists on the ground and say, I'm not settling. That's not even a waste of time, because number one, it's required by the court that you mediate, so you're going to have to mediate anyways. But number two, as attorneys, we know then what the sticking points are. We know what spotted cow or the sacred cow. Spotted cow. If you know, you know. That's a beer up in Wisconsin. But you know what the sacred cow is. You know what to go after. And if you go to a mediation and wife is saying, I'll pay husband $150,000 out of my retirement for the divorce, and that's the only issue that you're arguing over, and the husband wants $300,000 out of the wife's retirement account. Well, you know the wife's willing to pay $150,000 and the husband's willing to pay $300,000. You have now narrowed that issue. And so if it were to go to trial, in theory, and things always change and whatnot, you know that the only thing you're going to be arguing about at trial is the entitlement to the value of the 401k. So you've narrowed all of those issues. If not, it's not going to be on a written sheet of paper. The attorneys later on can stipulate to those types of things in what's called a pretrial statement, and we can talk about that in the trial podcast. But if that's the only thing that you guys are really fighting over, even if you didn't resolve it at mediation, at least you've narrowed the issues. And then that's going to help your attorney craft discovery and essentially effectively use your money to pursue the divorce case moving forward. So with all that being said, it's a no-lose scenario as long as you go to mediation and you actually participate in it and get some settlement offers going back and forward.
Yeah, it's funny because another good thing about mediation is, sometimes in divorce cases when they get a little bit more contested, motions start kind of flying back and forth. Not emotions, but actual motions filed with the court start flying back and forth. And whoever prevails on those motions is technically entitled to attorney fees. So what happens is, and also, parties that have disparate incomes. So you got, husband that makes twice as much income as a wife. The wife's attorney is going to be seeking attorney fees, reimbursement of attorney's fees. And under the law, in a lot of situations, the person with more money has to pay the other party's attorney fees, even if it's the other party that files the action. So what happens is, at mediation, if you reach a settlement agreement, 98% of the time, even if there are disparate incomes and there are attorney fee claims, all of it gets settled at mediation. So where each party bears their own attorney's fees. So that's not, you're already paying for your own attorney. You don't want to pay for your spouse's attorney. So if you get your case settled at mediation and you each bear your own fees, which is the result of most mediations, then you avoid it. But if you don't take mediation seriously, or you're unreasonable and your case doesn't settle and you have to go try your case in front of the judge, even if you might prevail on the one sacred cow that you were not willing to give up, or even if you're right on one issue that kept you from settling the case, you might have to owe your spouse's attorney's fees all the way up through trial just because you have more money, or because your spouse was able to prove entitlement to fees through motion practice. So mediation is a really good way to avoid being ordered to pay your spouse's attorney fees if the case doesn't settle and it goes to a family law trial.
The other thing about mediation too, and this is maybe the biggest issue with mediation, or the biggest benefit of mediation that we haven't even touched on yet, is that you and your spouse, for better or for worse, get to decide the outcome of the case. Okay. You two on that day, and you'll hear that at the mediation, all Florida Supreme Court approved mediators will give their opening spiel where they say, I'm we're here to mediate the case, and you and your spouse are going to be able to resolve that case today between you two. And I think that sometimes when we're going through things where there's a court system involved, you assume that the court is just going to side with you, because naturally as human beings, we think that we're right. Very rarely do we think we're wrong. If you do, that's great. You're emotionally mature. But most times in life, we think we're right. And that's just not how the court system works. And we've discussed that in previous episodes, that just because maybe you think you're right, when you actually apply the law and you apply the facts of the case, the law might say something different. So it's not necessarily always going to work out in your favor by any stretch of the imagination if you think that a judge is just going to rule on your side. Any attorney will tell you, I've gone in front of judges before and I've had motions that I could not lose, that I damn sure lost, and I had motions that I probably should not have won, that I won. It happens every single day. And it doesn't mean that the judges are wrong or right or good or bad. It's just the way that it goes. You've got somebody and a judge who's elected by the state of Florida, by the people of the state of Florida, or appointed by the governor, who hears an issue that you may have been fighting over for 2 months or 2 years in a 30-minute time slot, and has to make a determination and make a ruling. And they could be right, wrong, or neither. And very rarely are you going to be satisfied with the way that a judge rules, because inevitably it means that somebody else is telling you what to do. And you might think that you'll be satisfied with that, but you won't be, especially if it's a ruling against you. So if you bring this full circle all the way back to what I was saying earlier about how a great mediation or good mediation, usually both people are a little bit upset or a little bit perturbed. Oh, I can't believe that, I gave that up or whatever. It could be much worse if you go in front of a judge, because then you're going to be resentful and everything like that. At least you made the decision to give up maybe just a little bit more of your retirement account than you otherwise would have liked. Or maybe, just to get it past the finish line, you agreed to a 45-55 split of the marital estate in order for you to keep your retirement account. So you gave your wife 5%, or you gave your husband 5% of the marital property, or something along those lines. So mediation is a beautiful tool because you get to decide the outcome of the case as long as everybody agrees. And then, Matt, do you want to talk a little bit about mediation confidentiality?
Well, yeah, I mean, anything discussed at mediation is going to be confidential. So whatever, even if you get really close to an agreement, but you don't actually get a final agreement, when you leave that day, you start from zero. You haven't conceded anything. And that's really helpful because, you can, during the mediation, you can start kind of horse trading, and you can test kind of different, you can try to probe the other side to find out what the other side's sacred cow is. You're not going to be bound to any offer that you make in mediation unless it's a final offer and it's reduced to a signed marital settlement agreement. Even if you agree on every single issue and your case is completely settled, when you get the mediation agreement at the end of the mediation for you to sign, you can back out and walk away and not sign it, and you are not committing to any agreement. So you really have a lot of control in the process. That's what's nice about it. In a divorce case, you feel like so much is out of your control. A mediation actually feels like you're in the driver's seat and that you actually have some control over your future.
Yeah, for sure. And to shift gears just a little bit as it relates to Matt and I and our law firm, Matt and I are insurance defense trained attorneys, meaning that we used to represent insurance companies, the big ones with the, animals and characters on their commercials and all the ones that you see. And then thereafter, Matt and I both were personal injury attorneys representing people who were involved in car accidents. And family law is a lot different than personal injury and insurance defense for a variety of methods, or for a variety of reasons. And we can certainly talk about that on a different podcast episode. But one thing that is common is you go to mediation in those types of cases. And they operate a little bit differently, but they're also very similar in the sense that you're negotiating, you're going back and forward, and you're discussing money and trying to resolve. But they can be a lot more strategic with some of the moves and the information that you provide and things like that. And here's a tidbit if you've gotten to this point in the podcast for some advanced mediation strategy tips here. Don't give the other side all of your information at the beginning of the mediation. Okay. And this was something that I used to see a lot in insurance defense world when I was defending claims, is we would get a stack of 1,000 pages of medical records. And on page 729, there would be one little line and some scribble that says, plaintiff consumed 4 beers on the date of the accident or something like that. And you knew that the plaintiff's attorney didn't know about this because, let's be real, who's going to look through 792 pages of medical records and find a little scribble on there? And it's never been brought up, and the plaintiff testified in his deposition that he didn't have anything to drink that day or anything like that. So then you go to mediation, and you want to settle the case for $100,000, and the plaintiff wants $125,000. So in that world, you're kind of right there. You could split the baby a little bit, but let's just say both sides are just bumping heads, and you've been in mediation for 3 hours. That's when you want to bring up what's on page 792 of the medical records to get it over the finish line. Right at the very end, you drop that little nugget of wisdom. Hey, by the way, in the medical records, it says you were drunk on the date of the accident. Boom, case settles. Okay. It's the same thing with family law. All right. And I want to be very clear here. I'm not saying there's any deception here. I'm not saying you're lying. I'm not saying that you're not participating in good faith. I'm just saying if you
it's where you place your emphasis. That's it.
It's where you place your emphasis. It's playing your cards just like poker. It's anything else. So to go back to Matt's example about the sacred cow, if you know that your husband has a sacred cow, maybe it's the country club membership, okay? little tip of advice: fight over everything else. And when you get to the finish line and you're fighting over that last retirement account or that, some sort of savings account or something, say, how about this? I get the savings account and he keeps the country club membership. I'll sign over and transfer the entire membership to his name. He can have it. And boom, you have yourself a settlement. But if you just came out at the very beginning and said, yeah, I'll give my husband the country club membership, or I'll give my wife the country club membership, well, you don't have that leverage anymore. So if you, and this actually all goes all the way back to preparing for mediation. This is why it's important to work with your attorney. And I personally, and Matt's the same way, we like to schedule a time. I usually like to do it about 2 days before mediation, for a variety of reasons, but schedule time to speak with your attorney and go over everything. Hey, this is what I want. And then, hey, what do you think the other side wants? Where do you think there might be points of contention, and identify all of that. Take preparing for mediation very seriously. If you have a meeting with your attorney, don't blow it off. Show up and take it seriously, and, work with your attorney to go over everything for mediation so that your attorney is prepared. And go to mediation and see if you can't get the case resolved.
Yeah. And think twice about trying to go to mediation before even filing a case, because you're going to need to file that case anyways. All right. Well, that's going to conclude another episode of the Divorce Well in Florida, What to Know Before Your Spouse Does podcast. I'm Matthew Waring.
And I'm Brian Dunmire.
All right. A Fairway Law Group, Florida divorce law firm.